opposing this bill because, for many of the reasons that have been expounded by the previous speaker, it is an important bill on health and safety concerns. It undermines the health and safety of workers. Meal breaks are important not only to prevent injury, which can include death, but also so that people can just have a rest, be human and not be slaves to a clock working hour after hour without proper rest. And the original bill, if you look at the introduction to the bill, there doesn't appear to be anything really wrong with the status quo. It says that under the status quo, employers and employees are encouraged to work out mutually satisfactory arrangements that fit within current legislative provisions and can draw on the mediation services of the Department of Labour to assist them to do so. And apparently the air traffic controllers that have been used as an example for the bill going forward have worked out the situation together with their employers, so that is not a reason to proceed with the bill. And I think the greater harm, and it was outlined by the previous speaker, is that there is an unequal relationship in the workplace, and there's many a worker in non-unionised retail outlets, restaurants, etc., that do work long periods without breaks now. I know some of them myself, young people, a young 19-year-old I know, I talked to her recently. She was working in the shop. When do you get your breaks? Oh, we're very busy in this shop. Sometimes we go for hours without a break. And she wasn't aware even of the law. She wasn't a member of a union, and that is happening in workplace after workplace already. So rather than make it easy for employers to get away without appropriate rest breaks, we should stay with the present law and not proceed with this amendment. John Ryle, who's the National Secretary of the Service and Food Workers Union, he wrote an article criticising this new amendment, and he says that his union did submit to the Transport and Industrial Relations Select Committee and brought forward a case of a union member, an Indian immigrant worker, James Joseph, who had this problem of working split shift and worked from 10 to 2 and then 4:30 to 11. And when he insisted on having a short break every 3 hours, he was called a troublemaker and sacked. And he was told by the employer that it just wasn't possible because they were too busy. And that can happen in workplace after workplace. And to enable proper rest periods, sometimes the employer has to be subject to a certain inconvenience. That's the reality, to actually protect the health and safety, the rest periods of the workers. And that is what perhaps some people in the National Party don't quite understand. And it said, well, this is important for sole charge workers, for air traffic controllers. In the past, bus drivers have been used as an example. Well, it seems to me that the very people you would want to be the most alert to have proper breaks would be air traffic controllers and bus drivers, because it isn't just their health and safety that's concerned. If a plane comes down, all sorts of people will be killed, all sorts of families will be left with a tragedy. And similarly with bus drivers, a bus driver gets a bit tired and goes off the road, what happens? Or crashes into a car. So from any way you look at it, you shouldn't allow a law that gives so much looseness in it. And that's where it comes to this looseness of compensatory measures, that you're able to sort of go without a rest break for a few hours as long as you provide compensatory measures. And these are very ill defined as to their frequency, as to their length. There's just a bit in the legislation about, I think I've got the bit here. Come on, that the employer is entitled, that it can be time and lieu, it can be a different start and finish time. Exactly what that amounts to is not defined in the legislation. So you're setting things up for the employer to determine it without the worker, who's often in a very disadvantaged position, particularly if they're ununionised, to really correct the situation. And I think it's a departure from New Zealand's tradition. We have that old tradition going back through New Zealand's industrial history of awards with clear lunch and smoko breaks. And it is true that we're a bit more flexible now, but we don't want to depart too much from that tradition where, workers did have smoko breaks. You wouldn't call them smoko breaks now. Morning tea breaks and afternoon tea breaks, and at least half an hour for lunch. That's something that we grew up with, something that we were proud of, and something that differentiated us from the United States, for example, which didn't have such legislation. And I was quite horrified when I was, many years ago, when I was in industrial situations where we had the smoko breaks and lunch breaks and very rigid sort of times, to learn that in America they just didn't have any legislation protecting that whatsoever. And I think we've got to protect what we've gained over the years. So the Green Party will be opposing this particular legislation.